Joining us now to discuss the law around all this, Paul Callan, former New York City prosecutor, and David Priest, he's a former CIA intelligence officer, knows a thing or two about the laws regarding classified information. Paul, if I could begin with you, there are a few things we know the affidavit will not reveal with these redactions, any identifying information about witnesses, certainly as well about any agents involved, because concerned that they would be threatened. Do we know what this might show us about how prosecutors believe Trump may have broken the law here? We know the laws they're filing this under, but will it reveal anything about how exactly they make that case?
Well, of course, the judge in his order talked about restricting references to sources and methods, and he also talked about strategy, the strategy of the investigation. So I don't know precisely what he meant by that. We'll have to see when it gets released. But just stepping back and looking at the big picture here, this judge is the same judge who issued the warrant. And so he's well aware and was well aware of what was in the affidavit because it persuaded him to allow a search of a former president of the United States residence, an unprecedented act in American history. And I think that the judge feels there is other material that the public will see in this affidavit that will be very persuasive and will probably back up the judge's position and the Department of Justice position that the search was justified.
David, it sort of appears that this judge split the baby in effect because the former president said on his social media site that he wanted the immediate release of a completely unredacted affidavit. That would never happen, especially in a moment like this. However, Jay Bratt, who went to the court and said, don't release any of it because it could threaten and chill witnesses in this investigation and other investigations, also didn't completely get what he asked for here. What do you make of that?
Yeah, what I make of that is we're going to get a document with a whole lot of black rectangles in it. There's going to be massive parts of this that simply can't be released. And it's for all the reasons we've discussed. It's the investigation, it's the witnesses. It's also, we don't know who the subjects are here. We don't know if it is the former president solely or at all, if it's people around him. That information must be protected for the integrity of the investigation. On the other hand, I think we're going to be able to infer some interesting things from what is not redacted. Things like the time frame. If we get a 50, 60 page plus redacted document, there's going to be some language in there that we're going to be able to see about when different steps were taken. And if we can find out that there are pages upon pages upon pages at different points in the time frame between January 2021 and now, we'll learn a little bit about what investigators knew, when they knew it, and it gives us a hint as to what they're doing to find the answers.
Yeah, the timeline, the pattern. Paul, CNN has learned some details about Trump's strategy, and that part of the reason he resisted returning these documents was he was advised by Tom Fitton, who folks may know as the head of the legal activist group Judicial Watch, citing a 2012 case in which his organization sued for records from Bill Clinton's time in office. They lost. Now, we should note those records did not include classified documents as those kept at Mara-a-Lago do. Was that good legal advice from Tom Fitton to the former president?
I think it's probably not very good advice for the president because obviously the public is going to react very poorly to him taking particularly classified material, and not only classified material, but of course that SCI material, which is the top level of classified material. And anybody who's advising the president that it's okay for him to hold on to that stuff in a storage room at Mara-a-Lago, I got a problem with that advice.
So normally, and these are not normal times, nor is this a normal situation, David, but normally an affidavit would never be unsealed in any way, shape, or form, only if and until charges were brought. It's very possible that charges in this investigation are not brought against the former president. If that turns out to be the case, what happens with this affidavit? Because I think then you'll maybe have an even louder drumbeat of, then what was it searched for? Put it all out there, et cetera. Would it
certainly
then be fully, would there be any point when it would be fully unredacted and released?
It could be, but that is the entire reason why we protect the affidavit when it comes to potential subjects of the investigation. If charges are not filed, you don't want to tar someone's reputation with information in an affidavit, which, remember, has to do with probable cause. It doesn't have to do with any proof beyond a reasonable doubt. This is investigatory material, And you don't want to point the finger at somebody in public by releasing it, and they don't have a chance to defend themselves in a court of law at the time. So I think there will be a lot of redactions for that reason. Now, down the road, could it be released after the investigation is complete? I think there's more of a public interest claim at that point, but there still will be people, possibly including the former president, who might not want this information out there because it has a whole lot of investigatory steps that they can't defend themselves against within that process itself.
David, another deadline. Hard to keep track of all these deadlines, but a federal judge in Florida has given former President Trump till Friday to refine his arguments, this request for a special master to review these documents. Now we should note there was already a review team of a sort, a filter team as it's known, that's going through these documents to see if there are those that fall in the category of attorney-client privilege here. I mean, Paul, do you see this in your experience as something that's going to go somewhere, that a special master may indeed be assigned?
I think this motion has been made way too late in the game. They waited 2 weeks before they submitted this motion to the court. And as you've said, this filter team, which is traditionally what's used to take out attorney-client privilege material and classified material, has already been at work on the document and has seen the entire document. So I think the judge could rule, sorry, but you're too late with this motion. And I'd be a little surprised if he grants the special master. But there's no other case like this case involving a former president, so anything could happen here, Jim.
That's for sure. Paul Callan, David Priest, thanks both. Have a great weekend.
Thank you. You too, Poppy.